What does a Social Security disability attorney do with the evidence that doesn't support my Social Security disability claim? Well, what happens if your medical records don't support your claim, or your doctor has filled out a residual functional capacity form that says you can work, or the person that filled out that third-party form says you're a drunk? Can you deep six all that information? What does a Social Security disability attorney have to do with that evidence that doesn't support your claim? The Social Security Administration has rules and regulations that require me and any other Social Security disability attorney to submit all relevant evidence, regardless if it's good, bad, or just plain ugly. Lawyers are also governed by the state bar rules of ethics that require disclosure of relevant evidence, good, bad, or ugly. There's just no getting around it. But because the Social Security disability attorney is governed by the rules of ethics and regulations, we do have to disclose that. But the issue is, how can we handle bad facts? So how can a lawyer handle bad facts? First and foremost, we always tell the truth. We're always upfront with the court about bad facts. We don't hide the evidence. We explain the evidence. So, for example, there might be a conflict between what you said when you completed your application and what's happening now. We don't want the judge to seize on what we originally said and use that as a basis for denial. Or there might be a conflict between what a third party said and what you said at the time of the application. Or there could be a conflict between what you allegedly told your doctor about your symptoms and functionality and what's really going on. We've got to acknowledge these conflicts. But it's crucial that we explain what you were able to do, for example, when you applied, or when you filled out the activity of daily living forms, or how your symptoms and functionality have changed over time. We want to explain that change so that the judge isn't stuck on what you may have said in the past. It may be crucial that we explain that you only saw this physician several times, or that you saw the physician's assistant, or that you changed doctors because of communication issues, or that the doctor wasn't a specialist. We want to get around those issues. Now, it's also crucial that we address any issues with alcohol or drugs up front, including any treatment you're getting for those issues, when you last used alcohol or drugs, and the circumstances surrounding the use of alcohol and drugs. The Social Security law does not allow the judges to award benefits if the disability is caused by alcohol or drug abuse. Now, it's not uncommon for there to be bad facts or evidence in every case. These facts or evidence can come back and bite you if you don't have a lawyer that can develop a truthful strategy and story for dealing with these facts or evidence. We're always going to tell the truth, but we need to explain the bad facts in a way that is compelling and truthful so that the judge understands what's happening. I'll honestly tell you what I think about your case and how it might be possible to deal with any bad facts or evidence. And if we can't, I'll tell you that. I won't waste your time, and I certainly won't waste my time. You can learn more about your rights to Social Security disability benefits by calling me at 727-894-3188 for a complimentary consultation.